So today I'm joined by Jennifer Jancosek, who is an estate planning attorney at Jancosek Law, APC. Welcome, Jennifer.
Thank you for having me today, Scott.
All right, so why is estate planning such an important topic during this pandemic?
Well, this pandemic, it affects our health. So, of course, when it comes to life changes or a predicament where we may be ill, people start to consider putting together an estate plan. Now that every one of us is considering whether we could fall ill, whether we are young or elderly, it's now more important than ever to put together a plan for if those circumstances happen, just to make sure that your specific wishes are adhered to.
Now, the reality is, of course, for those that are affected by COVID directly, there's a very, very tiny, small percentage of people that actually succumb to the virus and essentially, pass away. So, is estate planning still relevant?
Right. Even though it's a small percentage, estate planning is absolutely going to be relevant because what we're doing is we're putting a plan in place for uncertainty. There could be a small percentage that we would still say get in a car accident or be, have circumstances where there's an earthquake that could create an emergency here in California. So even though it's a small percentage of the population, what we're really not looking at is, hey, what's the percentage that this can happen to me? And more along the lines of how can I prepare for if this happens to me.
Now, what would you say to those critics that say, such services are really flaming fear and capitalizing on fear and uncertainty drive sales for their products and services?
I would say that I've definitely seen that type of advertisements and things like that in the media today. But when it comes to my business and estate planning, we're always here. Whether you're getting married, you're having a baby, welcoming a new grandchild, it's not that we're capitalizing on what is happening today, but just reminding people of what services I provide and what value it can give to them as their circumstances have changed and the course of our lives have changed.
Yeah, I think that's a good point. And then I'm gonna come back to it, but I just want to kind of see it a little bit in terms of there are quite a bit of regulatory changes when it comes to estate planning laws. I mean, the kinds of framework that exists, regulatory framework that exists, and taxation framework that existed, let's say, 50, 30 years ago is obviously no longer relevant since the last, decade or so. So there are things that needs to be taken into consideration. Now, one of the things that you had mentioned to our team was that you try to utilize your blog as well, maybe some Facebook ads perhaps, and some of your content was blocked on some of these social media platforms because it had references to not necessarily even the term COVID-19 or pandemic, but things like advanced medical directive as an example. Can you elaborate?
Right. So we use Facebook to reach other people and provide information about estate planning. So a great way to do that is to put some money into advertising to make sure I can reach people locally in the state of California. So of course we had a blog about why you would need an advanced healthcare directive. And unfortunately, because it had medical terminology and emergency terminology, it was blocked by Facebook because maybe they didn't want to have that type of information available. And I'm sure it depends on their algorithm and what they allow. But unfortunately, we got blocked from that. And even though we requested an alternative review, that was also denied.
Okay. So, just speaking from just pure educational point of view, the discipline of estate planning is actually very broad and very complex. Can you get into a little bit of the more specifics underneath it in terms of all the various facets as far as, again, categories and some of the best practices that families should consider when it comes to estate planning?
When it comes to estate planning, you really break it down between a living trust plan and a will-based plan. And different people are going to have different life circumstances and assets that are going to determine whether one is right for them. So when it comes to me working with a person, I've got to get to know them on a personal level and see how their family's made up, what assets they hold, and especially what their plans are for their assets. So when people meet with me, the first thing I do is get to know them to see what specific documents I can provide them based on how their life is right now.
All right. So if you could, again, elaborate a little bit further in terms of the living trust or revocable trust versus the wills and the various testaments.
For a living trust, it's a great package for someone who may be a homeowner here in the state of California. Like you just mentioned before, there's always changes in our tax code and laws. And right now, we have a recent change to our probate code where anything over $166,000 will have to be administered through court, meaning it'll take a family time and money to get access to something just as maybe their parents' home. So with the living trust plan, what we get to do is put together an agreement where a person agrees to put their property in the trust. So when they pass away and the probate court would essentially freeze their assets, the living trust is seen as still alive. So they get to avoid going to court and property can be transferred more easily to their loved ones. If you don't own property, you still have the ability to control how your assets are dispersed to various family members and friends. And that's exactly where a will-based estate planning package comes in. Maybe you don't want the burden or the time of setting up a living trust and transferring your property. So with the will, you can put specific wishes you have. It can consider things not only such as personal property you give, like maybe a car or furniture within your home, but also fun things such as planning for a pet.
Okay. Now, many are turning to self-help books as well as online legal document service providers. Why do you feel that estate planning attorneys and professionals like yourselves are still absolutely needed to navigate some of the complexities and regulatory changes?
Well, the value an attorney provides is someone who is able to not only keep up with ever changing tax, local, and state codes, but also to get to know you and give you that analysis, legal reasoning to put together a strategy for you. Your plan. Unfortunately, it's not as easy as just taking a template or a form document, plugging someone's name and information in it, and getting it spit out and telling them, hey, this is what's going to protect your family and save you time and money in the future. There's specific clauses, and it's such a complex thing that's going to be different based on every person. So unfortunately, what we see is a lot of people who use online services end up at our offices for probate, where we end up having to file even though they had a living trust, and our offices will have to correct mistakes that have been made in the past. So even if a family thinks they're saving money on doing something themselves or having a plan online, it may cost their family more money in the long run because attorneys got to start from scratch and redo everything that was done in a DIY package or from maybe a book you bought on Amazon.
Now, talk about the subtleties of state to state and how each state has a different regulatory framework. And of course, you as an attorney, of course, are licensed at the state level. So, what are some of the things that's specific to state considerations?
Well, every state, we recognize each other's estate plans, but there's going to be different formalities and really rules of construction. A great example is here in the state of California. When I create a living trust plan, we have to have that plan notarized. My mom lives in the state of Florida. They do a little something different where not only does the living trust has to be notarized, but there's also a witness requirement where they need two people to watch that person signing and notarizing as well. So even though in different states, we're going to have different considerations that are really based on what our population's needs are. California, it's been said they're a knowledge-based economy. We've got a lot of different things going on here, especially being the fifth largest economy of the world. And it's going to have different considerations for, where I'm from in the Midwest and Indiana as well. So really what we look for as drafters is the different rules of construction, because I have had clients before who have property owned in several states. What I do is I consult with an attorney in that state to make sure we're adhering to those rules. So if it comes to the point where a person has to file for probate in that other state, we want to make sure it's not thrown out for something as simple as not meeting a witness requirement.
What do you say to those that say, well, if they have quite a large, let's say, investable assets or total assets, then it makes sense. But for those that are perhaps maybe in a certain asset or income brackets, estate planning maybe not as material. How would you respond to that?
Yeah, I've actually responded to this question many times because one of the biggest myths in estate planning is that maybe you need a large estate to put together a plan. And that's exactly what I mentioned before on will based plans. It's where a person can have power and control over what they're giving away and who it goes to. If someone doesn't get along with a child, if you don't get along with a sibling, that person can inherit property that maybe you don't want them to inherit. It's not about how much you have, it's about what you have and where you want it to go. And there's also many other things we can do with estate planning that doesn't have to do with tax and financial considerations. That's always the heart of it, of what we really discuss when we're putting information to the public, because it's something we're trying to break down from the IRS codes, the probate code, and provide it to people in a generality. But you can also do other things such as planning for minor children, planning for care of elderly parents. Like I said a moment ago, planning for care of pets. I've even helped a person put in a plan together where someone would take over for a bird. Some birds live to be over 50 years old. It sounds crazy, but if that's your life and that's something that's important to you, what we want to do is put it in a legal document, because when you pass away, you're no longer here to let people know what your wishes are. And unfortunately, I've seen it even with neighbors that have passed. Something as simple as a pet you loved your whole life, they'll be taken to the shelter, where you could put a clause and say, hey, my brother lives in Tennessee. I'm going to leave him some money to take care of Fido. That person knows that they have that right to do that. They'll take money on your plan to help take care of your pet. There's so many different ways that we can plan around your life and what is important to you. It's not just about dollars and cents. It's just that that's what usually drives people to putting a plan together, is that they want to save time and money for their family. But if you have certain wishes about your life and what you want to do, we can put those in those documents as well.
All right. And of course, the interaction and the document preparation review, all this can be done online. How can people learn more about the work that you do?
How people can learn more about me by checking out on our website at www.jancosek.law.
All right. So today I've been joined by Jennifer Jancosek, who is an estate planning attorney at Jancosek Law APC. Thank you for joining, Jennifer.
Thank you very much, Scott. Glad to be here.